The constitutional basis of federalism. The word federalism is absent from the Constitution, and not much was said about it at the Constitutional Convention. 18th century Americans had little experience in thinking of themselves as American firsts and state citizens second. In fact, loyalty to state governments was so strong that the Constitution would have been resoundingly defeated had it tried to abolish them. In addition, a central government working alone would have had difficulty trying to govern 18th century Americans. The people were too widely dispersed, and the country's transportation and communication systems too primitive to allow governing from a central location. There was no other practical choice in 1787 but to create a federal system of government. The division of power. The Constitution's writers carefully defined the powers of state and national governments. Although they favored a stronger national government, the framers still made states vital cogs in the machinery of government. The Constitution guaranteed states equal representation in the Senate, and even made this provision unamendable in Article 5. It also made states responsible for both state and national elections, an important power. Further, the Constitution virtually guaranteed the continuation of each state. Congress is forbidden to create new states by chopping up old ones, unless a state's legislature approves, an unlikely event. The Constitution also created obligations of the national government towards the states. It is to protect states against violence and invasion, for example. At times, though, the states find the national government deficient in meeting its obligations, as we will discuss later in this chapter. In Article 4 of the Constitution, the framers dealt with what remains a touchy question. In a dispute between the states and the national government, which prevails? The answer that the delegates provided, often referred to as the Supremacy Clause, seems clear enough. They stated that the following three items were the supreme law of the land. 1. The Constitution. 2. Laws of the national government, when consistent with the Constitution. And 3. Treaties, which can be made only by the national government. Judges in every state were specifically told to obey the U.S. Constitution, even if their state constitutions or state laws directly contradicted it. Today, all state legislatures and judges are bound by oath to support the Constitution. The national government, however, can operate only within its appropriate sphere. It cannot usurp the state's powers. But what are the boundaries of the national government's powers? According to some commentators, the 10th Amendment provides part of the answer. It states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. To those advocating states' rights, the amendment clearly means that the national government has only those powers specifically assigned to it by the Constitution. The states or people have supreme power over any activity not mentioned there. Despite this interpretation, in 1941 the Supreme Court in the United States v. Darby called the 10th Amendment a constitutional truism, a mere assertion that the states had independent power of their own, not a declaration that state powers are superior to those of the national government. The court seemed to backtrack on its ruling in favor of national government supremacy in a 1976 case, National League of Cities versus Usery, in which it held that extending national minimum wage and maximum hour standards to employees of the state and local governments was an unconstitutional intrusion of the national government into the domain of the states. In 1985, however, in Garcia versus San Antonio Metro, the court overturned the National League of Cities decision. The court held, in essence, that it was up to Congress, not the courts, to decide which actions of the states would be regulated by national government. Once again, the court ruled that the 10th Amendment did not give states powers superior to that of the national government for activities not mentioned in the Constitution. Occasionally, issues arise in which states challenge the authority of the national government. In the late 1980s, the governors of several states refused to allow their state National Guards to engage in training exercises in Central America. National Guards are state militias, but the Constitution provides that the President can nationalize them. In 1990, the Supreme Court reiterated the power of the national government by siding with the President. Similarly, South Dakota sued the federal government over its efforts to raise the state's drinking age laws and over its efforts to mandate a 55-mile-per-hour speed limit on highways. The The state lost both cases. In 1995, however, Congress changed the law on speed limits. Federal courts can order states to obey the Constitution or federal laws and treaties. However, in deference to the states, the 11th Amendment prohibits individual damage suits against state officials, such as a suit against a police officer for violating one's rights, and protects state governments from being sued against their consent by private parties in federal courts or in state courts. In 2001, the court voided the application of the Americans with Disabilities Act to the states, finding it a violation of the 11th Amendment in the case of Board of Trustees of University of Alabama et al. Versus Garrett et al. Cases arising under the 14th Amendment, usually cases regarding racial discrimination, are an exception. Suits may also be brought by the federal government against states in federal courts, and by individuals against state officials seeking to prohibit future illegal actions. Recently, the Supreme Court has made it easier for citizens to control the behavior of local officials. The court ruled that a federal law passed in 1871 to protect newly freed slaves prohibits individuals to sue local governments for damages to seek injunctions against any local official acting in any official capacity who they believe has deprived them of their rights secured by the Constitution or by federal law. Such suits are now common in federal courts. Establishing national supremacy. Why is it that the federal government has gained power relative to the states? Four key events are largely settled on the question of how national and state powers are related. 1. The elaboration of the doctrine of implied powers. 2. The definition of the Commerce Clause. 3. The Civil War. And 4. The long struggle for racial equality. As early as 1819, the issue of states versus national power came before the Supreme Court in the case of McCulloch versus Maryland. The new American government had moved quickly on many economic policies. In 1791, it created a national bank, a government agency empowered to print money, make loans, and engage in many other banking tasks. A darling of Alexander Hamilton and his allies, the bank was hated by those opposed to strengthening the national government's control of the economy. Those opposed, including Thomas Jefferson, framers and state legislatures, saw the bank as an instrument of the elite. The first Bank of the United States was allowed to expire, but then the second bank was created during the presidency of James Madison, fueling a great national debate. Railing against the monster bank, the state of Maryland passed a law in 1818 taxing the nation's bank, Baltimore branch, $15,000 a year. The Baltimore branch refused to pay, whereupon the state of Maryland sued the cashier, James McCulloch, for payment. When the state courts upheld Maryland's law and its tax, the bank appealed to the U.S. Supreme Court. John Marshall was Chief Justice when two of the country's most capable lawyers argued the case before the court. Daniel Webster, widely regarded as one of the greatest senators in U.S. history, argued for the national bank, and Luther Martin, a delegate to the Constitutional Convention, argued for Maryland. Martin maintained that the Constitution was very clear about the powers of Congress, as outlined in Article 1. The power to create a national bank was not among them. Thus, Martin concluded, Congress had exceeded its powers, and Maryland had a right to tax the bank. On behalf of the bank, Webster argued for a broader interpretation of the powers of the national government. The Constitution was not meant to stifle congressional powers, he said, but rather to permit Congress to use all means, quote, necessary and proper, end quote, to fulfill its responsibilities. Marshall, never one to sidestep a big decision, wrote his ruling in favor of the bank before the arguments ended, some said before they even began. He and his colleagues had set forth two great constitutional principles in their decision. The first was the supremacy of the national government over the states. Marshall wrote that if any one proposition could command the universal assent of mankind, we might expect it to be this, that the government of the United States, though limited in its power, is supreme within its sphere of action. As long as the national government behaved in accordance with the Constitution, said the court, its policies took precedence over state policies. Accordingly, federal laws or regulations, such as many civil rights acts and rules regulating hazardous substances, water quality, and clean air standards, preempt state or local laws or regulations, and thus preclude their enforcement. The other key principle of McCulloch was that the national government has certain implied powers that go beyond its enumerated powers. The court held that Congress was behaving consistent with the Constitution when it created the national bank. It was true, Marshall admitted, that Congress had certain enumerated powers specifically listed in Article 1, Section 8 of the Constitution. Congress could coin money, regulate its value, impose taxes, and so forth. Creating a bank was not enumerated, but the Constitution added that Congress has the power to, quote, make all laws necessary and proper for carrying into execution the foregoing powers, end quote. That, said Marshall, gave Congress certain implied powers. It could make economic policy consistent with the Constitution in a number of ways. Today, the notion of implied powers has become like a rubber band that can be stretched without breaking. The necessary and proper clause of the Constitution is often referred to as the elastic clause. Hundreds of congressional policies involve powers not specifically mentioned in the Constitution, especially in the domain of economic policy. Federal policies to regulate food and drugs, build interstate highways, protect consumers, clean up dirty air and water, and do many other things are all justified as implied powers of Congress. The Constitution gives Congress the power to regulate interstate and international commerce. American courts have spent many years trying to define commerce. In 1824, the Supreme Court, in deciding the case of Gibbons v. Ogden, defined commerce very broadly to encompass virtually every form of commercial activity. Today, commerce covers not only the movement of goods, but also radio signals, electricity, telephone messages, the internet, insurance transactions, and much more. The Supreme Court's decision establishing the national government's implied powers and a broad definition of interstate commerce created a source of national power as long as Congress employed its power for economic development through subsidies and services for business interests. In the latter part of the 19th century, however, Congress sought to use these same powers to regulate the economy rather than to promote it. The court then interpreted the interstate commerce power as giving Congress no constitutional rights to regulate local commercial activities, such as establishing safe working conditions for laborers or protecting children from working long hours. When the Great Depression hit, new demands were placed on the national government. Beginning in 1933, the New Deal of President Franklin D. Roosevelt produced an avalanche of regulatory and social welfare legislation, much of which was voided by the Supreme Court. But in 1937, the court reversed itself and ceased trying to restrict the efforts of the national government to regulate commerce at any level. In 1964, Congress prohibited racial discrimination in places of public accommodation, such as restaurants, hotels, and movie theaters, on the basis of its power to regulate interstate commerce. Thus, regulating commerce is one of the nation's national government's most important sources of power. In recent years, the Supreme Court has scrutinized the use of the commerce power with a skeptical eye, however. As we saw in the opening to the chapter, in 1995, the court held in the United States v. Lopez case that the Federal Gun-Free School Zone Act of 1990, which forbid the possession of firearms in public schools, exceeded Congress's constitutional authority to regulate commerce. Guns in a school zone, the majority said, have nothing to do with commerce. Similarly, in 2000, the court ruled in United States v. Morrison that the power to regulate interstate commerce did not provide Congress with authority to enact the 1994 Violence Against Women Act, which provided a federal civil remedy for the victims of gender-motivated violence. Gender-motivated crimes of violence are not, the court said, in any sense, economic activity. The Supreme Court announced another limitation on the commerce power in 1996. In Seminole Tribe of Florida versus Florida, the court dealt with the case of a right Congress had given Indian tribes to sue state officials to force good faith negotiations, in this case over a license to run a casino. Contrary to previous decisions, the court declared the 11th Amendment prohibits Congress from using the interstate commerce power to revoke states' immunity from such lawsuits by private parties. The principal effect of the decision will be to limit suits seeking to enforce rights granted by Congress within its authority under the Commerce Clause, which encompasses much of modern federal regulation. Several other recent cases have had important implications for federalism. In Printz versus the United States and Mack versus United States, both 1997 cases, the Supreme Court voided the congressional mandate in the Brady Handgun Violence Prevention Act that the chief law enforcement officer in each local community conduct background checks on prospective gun purchasers. According to the court, the federal government may neither issue directives requiring the states to address particular problems, nor commend the state's officers or those of their political subdivision to administer or enforce a federal regulatory program. What McCulloch pronounced constitutionally, the Civil War, 1861-1865, settled militarily. The Civil War is often thought of mainly as a struggle over slavery, but it was also, and perhaps more importantly, a struggle between states and the national government. In fact, Abraham Lincoln announced in his 1861 inaugural address that he would willingly support a constitutional amendment guaranteeing slavery if it would save the Union. Instead, it took a bloody civil war for the national government to assert its power over the southern states' claim of sovereignty. A century later, conflict between the states and the national government again erupted over states' rights and national power. In 1954, in Brown v. Board of Education, the Supreme Court held that school segregation was unconstitutional. Southern politicians responded with what they called massive resistance to the decision. When a federal judge ordered the admission of 2 African American students to the University of Alabama in 1963, Governor George Wallace literally blocked the school entrance to prevent federal marshals and the students from entering the admissions office. Despite Wallace's efforts, the students were admitted, and throughout the 1960s, the federal government enacted laws and policies to end segregation in schools, housing, public accommodations, voting, and jobs. In 1979, after African Americans began voting in large numbers in Alabama, George Wallace himself said of his stand in the schoolhouse door, "I was wrong. Those days are over, and they ought to be over." The conflict between states and national government over equality issues was decided in favor of the national government. National standards of racial equality prevailed. The national government is supreme within its sphere, but the sphere of the states remains large and an important one. Federalism involves more than relationships between the national government and state and local governments. The states must deal with each other as well, and the Constitution outlines certain obligations that each state has to every other state. Suppose that, like millions of other Americans, a person divorces and then remarries. For each marriage, this person purchases a marriage license which registers the marriage with the state. On the honeymoon of the second marriage, the person travels across the country. Is this person married in each state passed through, even though the marriage license is only in one state? Can the person be arrested for bigamy because the divorce occurred only in one state? The answer, of course, is that a marriage license and a divorce, like a driver's license and a birth certificate, are valid in all states. Article 4 of the Constitution requires that states give full faith and credit to public acts, records, and civil judicial proceedings of every other state. This reciprocity is essential to the functioning of society and the economy. Without the full faith and credit clause, people could avoid their obligations, say, to make payments on automobile loans simply by crossing a state line. In addition, because contracts between business firms can be enforced across state boundaries, firms incorporated in one state can do business in another. Usually the full faith and credit provision in the Constitution poses little controversy. An exception occurred in 1996 when courts in Hawaii recognized same-gender marriages. What would happen in other states that did not recognize Hawaii's marriages under same-gender principal partners? Congress answered with the Defense of Marriage Act, which permits states to disregard gay marriages even if they are legal elsewhere in the United States. Hawaii has since overturned recognition of gay marriage, but in 2000, Vermont accorded legal status to gay civil unions. It remains to be seen whether Congress has the power to make exceptions to the full faith and credit clause. What about criminal penalties? Almost all criminal law is state law, If someone robs a store, steals a car, or commits a murder, the chances are that this person is breaking a state, not a federal law. The Constitution says that states are required to turn a person charged with a crime in another state to the state for trial for imprisonment, a practice called extradition. Although there is no way to force states to comply, they usually are happy to do so, not wishing to harbor criminals and hoping that other states will reciprocate. Thus, a lawbreaker is prevented from avoiding punishment by simply escaping to another state. The most complicated obligation among the states is the requirement that citizens of each state receive all the privileges and immunities of any other state in which they happen to be. The goal of this constitutional provision is to prohibit states from discriminating against citizens of other states. If, for example, a Texan visits California, the Texan will pay the same sales tax and receive the same police protection as residents of California. There are many exceptions to the Privileges and Immunities Clause, however. Many of you will be attending public universities. If you reside in the same state as your university, you generally pay a tuition substantially lower than that paid by your fellow students from out of state. However, only residents of a state can vote in state elections. States often attempt to pass the burdens of financing the state government to those outside the state, such as through taxes on minerals mined in the state but consumed elsewhere, or special taxes on hotel rooms rented by tourists. The Supreme Court has never clarified just which privileges a state must make available to all Americans and which privileges must be limited to its own citizens. In general, the more fundamental the rights, such as owning property or receiving police protection, the less likely it is that a state can discriminate against citizens of another state. In 1999, the Supreme Court held in Sanez v. Roe that California could not require a new resident to wait a year before becoming eligible for welfare benefits that exceeded those available in the state from which the new resident came.